The uMkhonto, which is a political party, has vowed to include Jacob Zuma on its parliamentary list. The party says the former president will be in parliament, even if it means the constitution has to be amended. Joining us now is Tselane, chairperson of the Institute of Election Management Services. Terry, a very good afternoon, and thank you so much for joining us.
Good afternoon to you and to your viewers, and thank you very much for having me.
Just on the statement that has been made, and to take a few steps back, the issue here in contention with the former president is that he was convicted, and as a result, from our understanding of the rules and the IEC, based on that, he is not eligible for parliament, isn't it?
Well, I'm not well informed about the details around this particular case, but I will tell you in terms of the requirements of the relevant section that in terms of section 30, any person or a party can object against the candidature of any person, firstly based on the fact that they have not signed a declaration form, and secondly, that they have not signed a form that binds them to the code of conduct. And the last one, that they are not qualified to stand for an election. So I would understand that if there is an objection against any candidature of any person, that person would have gone through that particular process to ascertain as to whether the candidate against which they are objecting meets the requirements as contained within Section 27 of the Electoral Act.
And I mean, from here, the Electoral Commission of South Africa, the IEC, has indeed announced and upheld an objection against the former president to stand as a candidate in the upcoming elections.
Yes, I have heard that announcement being made, and therefore, as you correctly pointed out, all political parties against whom the Commission has made decisions during this objection process still have an opportunity to raise their issues against the objection as well as the decision of the Commission, and they can raise that with the Electoral Court. And I think if the MK party decides to approach the Electoral Court, they'll be doing that within the rights as contained within the legislation, particularly Section 30. Does give political parties that opportunity to approach the Electoral Court if they are dissatisfied or disaffected by the decision of the Commission.
Based on this, and from your explanation, they do have, I guess, a leg to stand on, or at least the law on their side to challenge, which, of course, whether that challenge will be successful or not will be something that will be determined by those that will be hearing the case, isn't it?
Absolutely. You may recall that in 2009, there was also an objection against the candidature of Mrs. Mandela. And by that time, the chair of the Electoral Court was Justice Mtiana. And Justice Mtiana, in his judgment, indicated or dismissed the objection against Mrs. Mandela on the basis that she was not sentenced to an effective term that was capable of being completed. So on the basis of that, Mrs. Mandela was then able to go to the to National Assembly. So there are quite a number of things that would obviously have to be considered before a decision is finalized by the Electoral Court. But also part of what I think is likely to play out is whether the Commission has also done its due diligence in terms of each and every candidate that is there to make sure that there is no free passage of people who don't qualify through other mechanisms, such as what we saw last time in the case of Tselane, where you had the mayor, I think it was Mayor Magwarela, who did not qualify to be a candidate, but who had free passage to end up being the mayor of Tselane. So those kind of reports that the commission would have done of due diligence on each and every candidate would obviously be called upon, and then the commission would have to present that information to indicate that it has also complied with its obligation in terms of the Constitution, assuming that they are the ones who are actually supposed to be administering Section 47 of the Constitution.
And just finally then, Terry, with this case, and I know you do say that you're not particularly privy with the details of the case, but then the IEC does say that, or the rules does say that if one has been sentenced to a period of 12 months or more in prison, by virtue of that, they do not qualify, isn't it? And in this case, the former president has served a period of more than 12 months.
I'm not too sure even whether he really served the period of 12 months. As I've indicated, I don't know the details thereof. But like I've indicated...
So if we put it in a case, sorry to cut it in there, Terry, but if we put it, say, any other candidate that has served a period of 12 months or more, let's forget the former president, any other candidate, would that then rule them out in that instance?
Of course it would, but let me put it also in the context.
Sure.
And then here we talk about the candidature for National Assembly, not necessarily candidature to be a candidate in the election. So there are quite a number of factors, and I'm not too sure at what level those factors have got to be taken into consideration when decisions are taken about membership of the National Assembly. Because all these issues that we are referring to are contained within Section 47 of the Constitution, and it only deals with membership of the National Assembly. In other words, it deals only with the 400 members of the National Assembly who are supposed to be sworn in as members of the National Assembly. Now, the issue that we are talking about here of imprisonment, it's one of the considerations, but some of the factors that exclude people from being members of the National Assembly, it's anyone who is paid by the state. In other words, it excludes all the teachers. It also excludes permanent members to the National Council of Provinces. It excludes also members of the provincial legislature. So I suspect that there may be a technicality here because, as you may be aware, that these elections are national and provincial elections, and therefore, all these categories are really qualified to participate in the elections as candidates. You can't exclude members of the provincial legislature from participating as candidates. But it may be dealing only with the acceptance into the National Assembly, because Section 47 only deals with membership of the National Assembly, not necessarily being a candidate in an election. Okay. And it is important because then it means a person who is occupying another portfolio, such as in the provincial legislature, of course would be excluded from having to enter the National Assembly. Because you can't have two positions. Okay. And again, the teachers also would have to be excluded because they are employed by the state. So it would mean that they would have to resign their positions in order to gain membership of the National Assembly. So there are quite a number of factors that would have to be taken into consideration before the issue is finalized.
Okay. No. Loud and clear. Terry Tselane, thank you so much for coming through.